Supreme Court condemns Allahabad High Court ruling on sexual assault case. Hi, you're watching the Free Press Journal and I am Sneha Biswas. The Supreme Court on Wednesday strongly condemned the ruling of the Allahabad High Court, which stated that merely grabbing the breast and pulling the string of a pyjama do not amount to the offence of rape. Taking motu cognizance, a bench comprising Justices B.R. Gavai and Augustine, Masih heard the matter and expressed severe disapproval. Justice Gavai called the ruling insensitive, stating, "It is a serious matter, total insensitiveness on part of the judge. This was at the stage of issuing summons. We are sorry to use such harsh words against a judge." He further urged the Chief Justice of the Delhi High Court, who manages judicial rosters, to take the necessary steps. The ruling was issued by Justice Ram Manohar Narayan Mishra in response to a revision petition filed by two accused individuals. They challenged the order of a special judge in Kasganj who had summoned them under Section 376 of the IPC rape, along with other charges. So basically on March 17, the Allahabad High Court ruled that the accused's actions did not amount to rape or attempted rape, but instead fell under the scope of assault or use of criminal force against a woman with intent to disrobe. The case originated from an incident that took place on November 10, 2021, when a woman and her 14-year-old daughter were returning from a relative's house. The accused, Pavan and Akash and Ashok, who belonged to the same village, met them on a rural pathway. When Pavan offered the girl a ride home, her mother agreed, trusting his assurance. However, the accused stopped the motorcycle on the way and began sexually assaulting the victim. Akash allegedly dragged the girl toward a culvert and pulled the string of her pyjama. Her cries for help alerted passerby, who intervened. The accused then threatened them with a country-made pistol before fleeing the scene. The special judge of the POSCO Protection of Children from Sexual Offences Court had initially summoned the accused under rape charges. However, after reviewing the case, the Allahabad High Court downgraded the charges, arguing that the accused did not attempt to commit penetrative sexual assault. The victim did not get naked or undressed due to their actions. The act of pulling the pyjama string and grabbing her breast was not sufficient proof of an attempt to rape. The High Court observed that to prove an attempt to rape, the prosecution must establish a clear determination to commit the act or that it had moved beyond mere preparation. The ruling has ignited national debate on the judicial interpretation of sexual assault laws in India. Many legal experts and women's rights activists argue that such observations weaken legal protections for sexual assault victims and set a dangerous precedent for women. What is your take on the matter? Do you agree with me? Write to us in the comments section below and don't forget to like, share and subscribe to the Free Press Journal. Thank you for watching.